On September 11th, a federal judge in the Eastern District of New York, which is a courthouse right across the bridge from here in Brooklyn, ruled on the application of federal securities laws to initial coin offerings, or also known as ICOs. And there have been a lot of reports in the media that the judge ruled that ICOs are securities offerings. And that's just false. So today I'm going to talk a little bit about how securities laws apply to ICOs and the significance of Judge Deary's decision. So under U.S. law, securities offerings are subject to a number of different legal requirements, including registering with the SEC. And companies that have done ICOs generally haven't complied with those requirements. Instead, they've taken the position that their ICO is not a securities offering, so they don't have to register. But under U.S. law, an ICO is in fact a securities offering if it falls within the definition of an investment contract. And answering that question is tricky. Because the test for whether or not an agreement, such as an agreement to buy blockchain tokens, constitutes an investment contract requires an analysis under this old court decision from 1946 called the United States versus Howey. And as Judge Deary put it in his opinion that came out on September 11th, the question under Howey is whether the elements of a profit-seeking business venture are such that investors provided the capital and shared in the earnings, and the promoter managed and controlled the enterprise that's created. And under this test, the only way to determine whether any particular agreement is an investment contract is to look at the nature of the agreement, look at the nature of what's being sold in the agreement, and then look at the action of both the buyer and the seller in connection with the contract itself. So the upshot is there's just not a simple litmus test for whether or not any particular contract, whether it's a contract to purchase tokens or a contract to purchase oranges, constitutes a securities offer. Every ICO and every contract is different. So the federal prosecutors in the Eastern District of New York brought charges against Maksim Zaslavskiy for committing securities fraud and conspiring to commit securities fraud. And the indictment, which was filed in the Eastern District of New York in September, summarized the factual basis for the charges. And the charges were pretty straightforward. They related to two different ICOs, the ICO for REcoin and the ICO for Diamond tokens. And the government said that the fraud concerning the REcoins was basically that the investors were told REcoins are backed by actual real estate that's owned. But there was no real estate that was owned. And the fraud that related to the Diamond tokens was investors were told that the Diamond tokens were backed by actual physical diamonds that were stored somewhere in the United States and were fully insured, but there actually were no diamonds. So in a sense, the allegations of fraud are very straightforward, and they don't have anything at all to do with the cryptographic nature of the tokens. They really have to do with the nature of the allegations that were made. So it's like if you sold Brooklyn Bridge coins, and the fraud wouldn't be that it's a coin or that it's cryptographic in nature, it's that you don't own the Brooklyn Bridge. So Zaslavskiy's attorney moved to dismiss the indictment, arguing that the defendant couldn't be guilty of the crimes he's charged with because the sale of these ICOs were not securities offerings. So he can't be guilty of securities fraud. And the judge denied the motion. But Judge Deary didn't rule that every single ICO is a securities offering. In fact, he didn't even rule that these two ICOs were securities offerings. Instead, he said, if you assume the truth of every single fact that the government alleges in the indictment, then a reasonable jury could find that these two ICOs were securities offerings. He left the decision up to the jury, and he said that these are questions that the jury is going to decide after the trial, and he refused to decide those questions. The most important thing to take away from this decision is that every ICO is different. It's a unique question as to whether or not an ICO is an investment contract, and there's no litmus test for every single ICO. Some ICOs are securities offerings, some ICOs are not securities offerings. And a lot of ICOs are in between, and it requires a careful legal analysis to determine whether or not the ICO would meet the definition of an investment contract under U.S. securities law. And the case also is an important reminder of something a lot of people try to ignore when they're doing ICOs, which is that if you know that you're doing a securities offering and you know that registration is required and you don't do it, that's not just a foot fault. It's a federal crime that's punishable by imprisonment. So it's incredibly important that if you're doing an ICO and you think there's a chance that U.S. securities regulators would conclude that that ICO is a securities offering, that you consult with an attorney first.